somebody was having a Twitter spat with Felipe and they wanted to involve me. I have no issues with Felipe as long as he doesn't hold himself out to be an attorney ever again, unless he actually goes to law school and gets a law degree and passes the bar exam and gets admitted into the California State Bar or some other state's state bar. Then I won't have any issues with him calling himself an attorney. But until then, I have no issues with him as long as he doesn't call himself an attorney. For reasons unknown, he tweeted this. I'm not a Twitterer, so I think it's called a tweet. It's called a tweet. Yeah, it's called a tweet. Anyway, I'm not saying he's endorsing this or not endorsing it. I don't know his stance on Luck Foyer's Institute, but he did tweet this out. Portland wants to kill homeless transit people. USDC Oregon agrees. So Mr. Luck Foyers in this video, he starts off saying that his house was taken from him in 2005. He tried to fight it with a Rule 60b-4 appeal or argument or something along those lines. I don't know if he retained a lawyer for it. He didn't say. He argued that the court clerk hadn't taken an oath. Oaths are very simple, very easy to take. You're not required to produce them on demand. You can file, probably, I should have checked on this before I looked at it, but there is probably some form you can file in North Carolina akin to a FOIA request or some sort of a open, or what do they call it, Sunshine Act or Open Records Act or something like that. They'd probably have something like that in North Carolina, I would assume. And you're wondering why it matters what the court clerk has to say. It is because, weirdly, in North Carolina, the clerks of the Superior Court shall have such jurisdiction and powers as the General Assembly shall prescribe by general law uniformly applicable in every county of the state. So the Superior Court is a court of original general jurisdiction. So what that means is that pretty much any case can be heard first in the Superior Court unless the General Assembly has stated in that action that it has to be heard by some other court first. The clerk of the Superior Court can hear such cases as the General Assembly has said specifically that the clerk of the Superior Court can hear. And I believe also the assistant clerks of the Superior Court have that capacity, but not deputy clerks. So, anywho, so he says that the clerk didn't have the oath filled out, but as you can see, the oath is just a minor thing. All you do is you enter your name. You would probably have what position you are going to be working in, like judge or court clerk there. So you've got to fill in your name, and then you swear to it in front of a notary or a judge or somebody like that, and then they send it someplace, and you never see it again. And then somebody says, "Hey, show me your oath." And you're like, "You're a sovereign citizen." And they're like, "There's no such thing as sovereign and citizen are mutually exclusive. Yeah, there's no such thing." And you're like, "Yeah, you're definitely a sovereign citizen." Anyway, enough of that tangent. So he claimed that all the court clerks don't have this filled out, and so therefore they are all in violation of 14-229 of the North Carolina Penal Code or statutes or whatever they want to call it. Anyway, if you believe him, that's great. If you don't, that's fine too. What Mr. Luck Foyers goes on to say is that because he lost his house and he had to wage that horrible, nasty lawsuit to try to keep it and lost that lawsuit, he developed PTSD, and the ADA requires businesses and political agencies and things like that to make reasonable accommodations, or to allow for reasonable accommodations for people with disabilities. I don't know if Mr. J. Vincent Shore has been diagnosed legitimately with PTSD, and it really doesn't matter for this storytelling. But he is a sovereign citizen, and he does believe in word magic. Let's see if I could find it in here. I probably should have had it queued up. This is the first video that he did, or at least it's the first video that was available on his channel. Of course, he disabled comments and hid the like to dislike ratio, because that's what people who believe in free speech do. So he says the issue is a magic word. And yes, he does believe in magic words. This whole video is about the magic word kind of thing. This video is without the ability to concisely examine the multiple meanings of the words United States. Yeah, he is a word magician. And his latest bit of word magic is reasonable accommodation, because the ADA says that these agencies and businesses and whatnot have to make reasonable accommodations. What he fails to understand is that he does not get to determine what a reasonable accommodation is. A judge would determine that if he brings a lawsuit alleging that somebody did not give him a reasonable accommodation. Then the judge will look at it and say whether or not it was reasonable. However, he did get a doctor to sign off that his bus, which he lives in because he is homeless in Portland, and his car, a Dodge Neon of some indeterminate year, are reasonable accommodations for treating his PTSD. Imagine my shock when courts don't find that persuasive. So Mr. Luckfoyers parked his bus and his Dodge Neon on a street that has no parking signs along it. Imagine my shock when he gets tickets and tow warnings. Imagine my shock when he ignores those tickets and tow warnings. He tries to play it smart. This is the tow warning. If this vehicle is not completely removed from the public right-of-way, it will be towed by order of the city of Portland. He says, well, the street is the public right-of-way. How do I completely remove my vehicle from the street? You pull into a parking lot? That would do it. Or a driveway. Rent a space at an RV park. Go to a street where there's parking allowed along the side of the street and park there. I'm not a genius, but there's lots of ways to remove your car from the public right-of-way, or your vehicle. Or if he's a real sovereign citizen, it would be his vessel, right? Admiralty laws and all that. Well, the police actually tried to tell him that. Oh yeah, they're stealing from him. The police officer, in response to his request for having an ADA representative, damn it. He makes clear he's not asking for an exemption. He's totally asking for an exemption. He wants reasonable accommodation to leave his vehicle where it is, on a street with no parking signs. I wanted an accommodation of having someone explain to me how I'm supposed to remove my vehicle from the public right-of-way. Well, the police officer obliges. He says, take it someplace else. Take it to someplace where there's no parking signs. That will satisfy us. And Mr. J. Vincent Shore proceeds to argue with him, and then is magically dismayed at how his vehicle got towed. Then he doesn't understand how the city gains authority over vehicles that are geographically within the Portland city limits. Because Portland is sovereign over everything that goes on within its city limits, except as not allowed by state or federal law. If the state law prohibits Portland from doing something, then Portland can't do it. If federal law prohibits Portland from doing something, then Portland can't do it. Other than that, Portland gets to control what goes on within its city limits. That's how this works. Genius. Yeah, so the judge's answer, because I said so. The judge, yes, if the judge makes a ruling, this is in the traffic court. He took this to traffic court, and then he tried to make a special appearance to challenge jurisdiction, because in civil cases you can make a special appearance to challenge jurisdiction, but you can't in criminal cases. And believe it or not, a traffic ticket is not a civil case. A city or a state may treat parking tickets as civil matters. But if you don't pay them, what happens? They issue a warrant. If you don't pay a civil penalty, or not penalty, but like if you have a judgment against you for whatever amount, they don't issue warrants. They may try to attach your property or execute liens on your bank accounts, or levies, I should say, on your bank accounts, or garnish your wages or something like that. But they can't get a warrant for your arrest. So that's how you know if you don't pay a ticket, if you get a warrant. I mean, it's even if they call it civil, even if they call it a civil infraction, it's basically a crime. Treat it as a crime. You don't get to challenge. It's not actually a civil suit. You don't get to make a special appearance to challenge jurisdiction. You have a few options. You could pay the ticket, and then basically it's just a default judgment against you, and the money that you paid goes against it, and it's all no fuss, no muss. You can challenge it, in which case it's treated just like a minor misdemeanor. You go in front of the judge. They use very basic rules. The ticket is basically the complaint, the criminal complaint, and they kind of proceed with it from there. But it's not, you don't get to make special appearances. It's the minor things that really trip you up. Anyway, he plays lots of games, lots of word games. He doesn't understand anything really. Yeah. Anyway, so let's look at how well he does these things. This is Shore v. City of Portland. He filed this one quite a while ago. Informal pauperis, so we're paying for it because it is in a federal district court, so the federal government is paying for it. He's just getting slapped around silly in it. He gets all of his motions denied. He did get the informal pauperis, but he's homeless, so that was almost for granted. The magistrate judge has said that the PPB, which is like the Portland Parking Bureau, and the PBOT, which is like the Portland Bureau of Transportation, I think, I could be wrong, doesn't really matter, and the Title III should be dismissed with prejudice, and the Title III claim should be dismissed with prejudice. I don't know if anything else is in there. So he's losing bad. As soon as Judge Marco Hernandez signs off on it, which is what, the 4th? Yeah, so they have to make objections by June 4th. So 2 more days. And then Judge Marco Hernandez is going to sign off on it. This is Judge Marco Hernandez right here. You may wonder why I have this up. This made it to the legal, so we actually get to read it. This is by Marco Hernandez, so we can see a little bit of it. It's a 1983 suit and a American with Disabilities Act suit. So before the court is plaintiff Jay Vincent's motion for a temporary restraining order In a September 29, 2017 order, the court denied plaintiff's prior TRO included in his complaint. See order, blah, blah, blah. The court concluded the plaintiff had failed to demonstrate a likelihood of irreparable harm or a substantial likelihood of success on the merits. Now, plaintiff reasserts substantially the same arguments the court previously rejected. For the same reasons explained in the September 29, 2017 order, the court denies the plaintiff's renewed motion for a TRO. In addition, because the plaintiff's request for relief is denied, the court also denies his request for a preliminary injunction hearing. So, that's interesting, right? What's even more interesting is that Shore then sued Hernandez. October 10th of 2017. And this was October 5th of 2017. I wonder why he sued. Well, so this is again informal pauperis. Again, well, in this case, the district had to bring in a United States district judge from a different district, from the Western District of Washington. So they had to bring him in because he's suing a district court judge in Oregon. So we, the taxpayers, because this is all informal pauperis, had to pay to bring in a judge from another district. Thank you. But it was a fairly short-lived run. It was a 14-day run, and it was dismissed for failure to state a claim. That means that even assuming everything that the claim said as true, as a matter of law, there's nothing there that they could actually adjudicate for in the plaintiff's or adjudicate for the plaintiff on. It's like if you allege that somebody battered you. You say, I'm suing you for battery. And then in your complaint, you lay out all of the elements of trespassing. But you never once say in your complaint that the person actually touched you in any way, shape, or form. Then your case would get dismissed for failure to state a claim. Giving plaintiff leave to amend would be futile, the court says. The case is closed. The clerk is directed to send uncertified copies of this order to all counsel of record and any party appearing pro se at said party's last known address. So he doesn't have a stellar court record. These are all I could find. I may go into the law library on Monday if I have time and see if I can't scrounge anything else up that may have made it into LexisNexis or Westlaw. I don't know. I don't think anything made it into the appeals court because that would have probably come up from like Justia or one of the other websites. But anyway, he has no understanding of the law and he thinks there's word magic, and he loses his cases, and he sues the judges who rule against him. So I'm going to go with Felipe Hemming is retweeting a sovereign citizen. Do with that what you will. Thanks for watching. Have a great day.